morning, everybody. I think we're going to be starting soon. Isn't this a wonderful day for a congressional briefing? Okay. Well, again, good morning, everybody. Thank you very much for being here. My name is Cynthia Lum. I'm the director for the Center for Evidence-Based Crime Policy at George Mason University. I just wanted to take a very short time this morning to extend a very warm welcome to all of you this morning on behalf of myself and also Professor David Weisberg, who is our executive director of the center. He was unable to make it today, and he sends his regrets. But we both extend our thanks to all of you for taking time out of your busy schedules to join us this morning. We are so very fortunate today to be able to partner with the Pretrial Justice Institute to provide the congressional briefing. And I'm joined by Executive Director Tim Murray and incoming Executive Director Charisse Fano-Berdine. Where is Tim and where is Charisse? Let me see if I can. Tim and Charisse. I really just want to thank both of you for your leadership in pretrial justice and also for working with us on coordinating this important briefing. Your efforts, as many people here already know, has really been extraordinary in this priority area for the Department of Justice, and so we very much appreciate it. I also want to acknowledge the efforts of CEBCP's Deputy Director, Dr. Charlotte Gill, who helped coordinate this event, as well as our research assistants, who you've met outside, Kirsten Hutzel, Julie Greco, and Heather Vovak, who are here helping to register folks. And finally, I'd like to acknowledge Congressman Jim Moran's office for providing us with really this beautiful space for us to have our briefing this morning. I am very pleased to announce that today we have 8 of the top researchers on pretrial justice here with us to present to you what we know and also what we need to know in the future about pretrial justice. I'm going to be introducing them each in turn before each of their briefs, and has been the tradition of CEBCP congressional briefings. Each researcher will have 8 minutes exactly to present their presentation. We've only deviated once in the 7 years of congressional briefings, so it's a very proud tradition, and we will keep to that today. After the first 4 presenters, we're going to take a brief break at the turn of the hour for question and answers, and then we're going to resume with 4 more briefs and then take a final question and answer session at the end of those 4 briefs. I encourage everyone to stick around afterwards. We have the room for a little bit of time afterwards to speak to the speakers or to mingle. You're welcome to stay. But without further ado, and to give the subject of research in pretrial its due introduction, I'm very pleased to introduce our session's moderator today, the Honorable Judge James Carr. Judge Carr is Senior United States District Judge for the Northern District of Ohio. After having served as a U.S. magistrate from 1979, he was nominated by President Clinton and received his commission on May 9, 1994. He's served as a board member for the Pretrial Justice Institute since 1989 until December 2013, and last year he served as the chair of the Pretrial Justice Institute Advisory Board. So it's my very distinct pleasure to welcome Judge Carr today. Judge Carr, thank
you. In the mid-1960s, a New York City businessman by the name of Louis Schweitzer had occasion to visit the detention center in New York City, and he realized, upon having seen what he did, that vast numbers of people were being held awaiting trial who could safely be released. This led and caused him to found the Vera Foundation, which he named in honor of his late wife. He funded it, and that was the beginning of what commonly is referred to as the bail reform movement. That movement continues apace. Its objectives and the objectives of organizations like the Pretrial Justice Institute are far from being fully accomplished, both at the federal level and at the state level, despite the fact that we have the Bail Reform Act, which Congress enacted shortly after this movement got underway. And certainly within the states, there's also much to do. You are here to learn about the research that is going on in that area, and I hope that you have the question, well, why does research in this area matters? We've got legislation, we've got bail bondsmen, we've got other means and methods of holding people. It matters for many reasons, not the least of which is that those of us who are opposed to the concept and the practice of using cash as a means of ensuring appearance. In other words, and that's what gives rise to the bail bonding industry. And the bail bonding industry is not just the person on the corner storefront office with the sign in his window that says freedom is but a phone call away. And unfortunately, those signs and those people exist in most major cities, not in the District of Columbia. And the district itself really is, I think, a shining example of how, in fact, a major urban area with significant crime problems can, in fact, abandon cash bail, reduce failures to appear, and ensure community safety. But much remains to be done because the bail industry is a very well-funded industry. It's not the guy on the corner, the man or woman on the corner. It is the surety companies in this country. The bail bondsman, let's say there's a $5,000 bond, he'll pay $500 to buy a surety bond, he gets a promise, an IOU from the defendant or his family to pay the rest if he doesn't appear, and then the bail bondsman lays that off with a surety company, which makes tens, if not hundreds, those companies make tens, if not hundreds of millions of dollars a year. It is a thriving industry, a very powerful industry, and a very difficult opponent to challenge. One of the problems in challenging the bail bond industry, which is something I've been involved with for about 30 years now, is we don't have the facts that can prove, and we are convinced that they can prove, that indeed abandonment of cash enhances community safety and increases the likelihood that defendants will appear in court. That may seem to some of you to be a startling concept, but we are confident that that is the case. There are states, just like the District of Columbia, that do not, that live without bail bondsmen, that live without cash. But what we need more than anything is research that enables us, instead of telling anecdotes, which is what we rely on, just like the bail bond industry, when we appear in front of state legislators or in front of groups like this to present our different challenges and perspectives. We don't have the research, and we need it. And it is, I think, quite candidly, the principal need in the area of pretrial justice reform and challenging the bail bond industry. When they come to people like you and say, taxpayer pretrial services, you don't have to do that. We provide a free service. It doesn't cost the taxpayer anything. It does cost the taxpayer because they will take out only those people that they have some confidence are going to appear. That means a lot of people stay in jail awaiting even on nonviolent misdemeanors throughout this country who could safely be released, who would appear for trial, and who would not be a danger to the community. Who pays when a person is incarcerated and loses a job? What are the consequences of that? Sooner or later, the taxpayer pays. But again, we don't have the research that enables us to come to Congress, to state legislators, to county commissioners, to local judges, and say there is a better way than the historical, archaic, antiquated, and ultimately extremely expensive cash bond system. We don't have that research, and the people from whom you're about to hear today are doing that research. We need more of it, and at the end of the day, or at the end of the 2 hours, we hope, we'll be at this podium, that your question, well, why does research in this area matter? Don't we have a system that functions and works, and why should we bother worrying about change or reform? I hope at the end of the day, you'll come to agree with us that research is important, it counts, more of it needs to be done, so that legislators, not just congressmen, but those at every level in our country come to understand that reform is possible and why and how it can be accomplished. So welcome to the session this morning. I hope you will find it informative. I know I will. I'm still learning in this business, It's an exciting area of endeavor to be in, and someday, perhaps, we will achieve final success. So thank you for your attendance and participation this morning. Thank you.